Hi, my name is Megan Naughton. I'm an immigration lawyer at the law firm of Babson & Cole in Hartford, Connecticut. A company must be in existence, so they have to have a taxpayer identification number. They also have to have enough work for someone to do so that the work is considered sufficiently professional, sufficiently specialty occupation work. This would be work that would require a bachelor's degree of someone doing it. So it can't be really very administrative or really technical, sort of a lower skilled nature. So those are the two requirements baseline for an employer to have H-1B workers. In order to sponsor someone for H-1B status, the company does have to make several certifications. Among them, it has to certify that it's going to pay the person it's sponsoring the higher of the actual or the prevailing wage for the position. So this means it can't pay them lower than it pays other people that are working for the company in the same position. It also means it has to check in with the Department of Labor about what other people in the geographic region are being paid for the position. There's also record-keeping requirements that require a public access file to be kept to show, if asked, the wage offered for the H-1B petition, the prevailing wage determination the company received, and the company must post notice to let other people at the worksite know that it is sponsoring an H-1B worker. The other attestations include certifying that there is no strike or lockout at the worksite. I think that companies probably shy away from sponsorship because they are concerned about a couple of different things. A lot of companies think they may have to prove that they couldn't find a U.S. worker in order to sponsor someone for H-1B status. However, that is not the case. Proving that you can't find a qualified U.S. worker is not a requirement for the H-1B process in most cases. That only comes into play if you're sponsoring someone for green card in some cases. So that's probably the number one reason. Of course, cost is also a consideration, and I would think that reasonably so. It usually costs around approximately $5,000 probably to sponsor an H-1B worker, including USCIS fees and attorney's fees, although that's just an estimate. The other reasons that someone may not want to sponsor an H-1B worker is just sort of fear of the unknown, not knowing what is required in the process, but any qualified immigration lawyer who has done this process before would know the H-1B program has been around for quite a while. It can be very straightforward for someone to apply for or sponsor someone for H-1B status. The company would secure an immigration lawyer at the beginning of the process to work with. They would collect information from the employee that they're seeking to sponsor, past immigration status and their academic credentials. The lawyer would likely ask them for a copy of the job description, the offer letter, and talk to them about the requirements that they are paying at least the higher of the actual or the prevailing wage. The lawyer would have them post 2 notices regarding the process that don't name the employee but do contain a salary range at 2 locations that are conspicuous at the work site where the employee will be working. Basically it's some paperwork then to sign to make sure it's accurate and then to file with the U.S. Citizenship and Immigration Services. In my experience, or in my opinion really, the benefits that I've seen with my employer clients of hiring international workers have been, sort of all over the board, a mixed bag really. One thing I can say is that there have been employers who have clearly stated to me that they feel an increased sense of loyalty from their employees, who they've sponsored, who they've been with through that process, and who they've assisted in making their home in the U.S. That is for certain. I think also what we have seen is an increased interest perhaps among folks that are from outside of the U.S. in perhaps taking multinational global assignments, moving around the U.S. Perhaps more than people who may be from the area. Again, that's just anecdotal evidence that that may be the case. I think also that they benefit from the diversity that an international workforce or an H-1B worker can bring to their offices, different perspectives from around the world, and that enhances their business in many ways that are unmeasurable. An employer who is looking at or recruiting on campus for a position that it's seeking to fill would likely meet a student who's international here in an F1 visa, who would be entitled to work for a year after graduation on something we call optional practical training using an employment authorization card. The employer would want to tickler or sort of calendar an item for itself to look at sponsoring the individual for H-1B status starting in about January or February of the year before it would file the H-1B petition. So in our current system, we have a system where we can start to file H-1B petitions for students on April 1st of any given calendar year for their actual H-1B status to start on October 1st of that calendar year. So, you start checking in with a U.S. immigration attorney, talking to the student about it probably in January or February before that April 1st deadline to make sure that you have time to get everything done. The employer would want to have a good job description, know what the offered salary is, and just be willing to have someone be the point person at the company for the immigration process.